Arguments were done on both sides for the judge to make his final decision tomorrow morning. It's basically the prosecution needing more time to cross-examine some of his witnesses because they're claiming they got information at the last minute. Kevin says he's really worked hard to put his witness list together. He hasn't objected to anything. He says, to suggest they need time, I feel they're more than capable to cross-examine. She says she didn't feel it was a serious S attempt. The methods that were chosen were insufficient, whereas the method she used for the children was sufficient. Seems to be a debate. Her hanging out the window thing, if she landed on her head. Then she asked, well, can she get a witness to rebuttal? And he said he would consider that, yes.
Very serious business. And we've all been working very hard on the discovery, which, as you can tell, is voluminous. Hundreds and hundreds and hundreds of pages of state police interviews. And I mentioned, about with the government. They have cops, they have people going out and interviewing, they have videos, they have chemists, they have detectives, they have local cops. They want a cup of coffee, they can send 5 cops down the street to get one. I'm it, except for my son Patrick, who helps me out getting coffee, all right? And the reason I sound frustrated is that they're objecting 2 weeks ago because they need time to review, to cross-examine doctors on very basic items of evidence that are their items of evidence. Not one of those witnesses is adding or bringing anything new to the discovery, if you will. And not by way of excuse, but, I am a sole practitioner. In the past, May, June, July, in the past 3 months, I've had a murder, a rape, and 2 back-to-back federal trials that ended 1 week before we impaneled on this case. I have worked really hard to pull this case together with expert witnesses, civilian witnesses, private investigators been investigating. I provide everything to them as soon as I get it, and they have been doing the same with me. I haven't objected to one thing that they have offered. They put an AutoCAD, computer animated display disc on my desk last week. I didn't complain about it, run to you and try to exclude it. I said, fine, no problem, put it in my pile and move on. That's it. So to suggest that they need time to be able to cross-examine both, I've had trials with both of these prosecutors. They're both experienced. They're very, very familiar with the trial of major criminal cases. I feel that they're more than capable of being able to cross-examine, for example, number one, Dr. Volkovich, who is a board-certified emergency medicine physician. His report indicates that he has taken a look at South Shore Hospital, he's taken a look at the Brigham and Women's Hospital, he's taken a look at the photographs. That's their evidence. That's all he looked at. And all he's doing is basically what all of their South Shore doctors came in and testified to as to the nature of the injuries, in his opinion.
Her at Brigham and Women's, but we didn't know that this would even be an issue until a week before trial. And again, this letter is dated July 26th, and it doesn't tell us which records, which reports, or which what medical journals or training or anything that these opinions are based on.
Well, that could be done by voir dire. I mean, the Commonwealth has at least inferred through their case that this was not a serious, right? I mean, and there's questions about whether or not somebody's hanging outside the window or not. And so why wasn't this an issue that the Commonwealth could have anticipated would come up?
The position of the Commonwealth isn't that it wasn't a serious, it's that the methods that were chosen were insufficient to achieve the goal. And the reasons for that, we would argue in our closing. I don't think we have to disclose that theory at this point, but we've never said it wasn't a serious. We've endeavored to develop from the testimony is that the methods that were chosen were methods that would be unsuccessful, but we're not saying it wasn't a serious attempt. And I think the reasons for that will become clearer when the doctors give their testimony. But it's our position that she was attempting, and there are various reasons and factors where she was unsuccessful, successful.
But there's been all kinds of testimony regarding, it seems to be a dispute of whether or not she's hanging from the windowsill or goes out head first. There's some testimony that's been raised, even with the blood experts, and things that she may have been hanging from the windowsill. Dr. Lapasato, it seems what they're seeking is those injuries are consistent with somebody who lands on their head.
So would the court allow us to call a witness who's not on our witness list to rebut that evidence?
Yeah, I would consider that.